And I think it's real relevant right now, obviously, with the change in what's happening to the music industry and also the film industry. Property or intellectual property can trace its roots back to England, probably about 300 to 400 years ago, with statutes of Anne that were originally created not as intellectual property statutes, but ultimately as a way to encourage learning and to keep the monarchy, which was still relatively powerful at that time, from being able to censor and control what was published. The people who framed the United States Constitution in the late 18th century were very learned people, were very much aware of this. They came from the creative arts or were inventors. If you look at the people that were at the Constitutional Convention, it wasn't just lawyers that were sitting there. There were people who did invent and who did, in one way or another, create intellectual property. And they were aware of the Statute of Anne and of this growing concept of the abstraction of having property in forms that were not tangible. And so copyright, the reason I give you that background is that copyright is and has always been a form of property law or property rights. Just like you own your land, you own your clothing, your car. In certain contexts, you can also own your ideas if they're expressed or in some sort of form that falls within the umbrella of intellectual property. Now, this is really significant. You're sitting there, you might be thinking, well, gee, I'm a musician or I'm interested in the music business. Why do I care? Well, I mean, obviously, it's what's happening right now. You probably are aware of. It'd be hard not to be aware of the tremendous changes in the music industry, but you care because copyright is the theory, publishing is the business application, and publishing is how you get paid ultimately, or not get paid. So, we look at the law abstractly and talk about copyright law, but the people who are really applying it are the publishers. And I think I've probably used this analogy to death, but when we look at deals in the music industry, we're always looking at the front of the backgammon board, and we're looking at record deals. And you'd always read about somebody signed to a 5-album deal or a 7-album deal, and that's the big, sexy headline. But the real long-term business deal, as it were, is in the back of the board, and that's always the publishing. And basically, they administer and exploit the copyright, which is the actual property right in the expression, in this case, in the music industry. In the underlying music. Well, yeah, copyright law in the United States, we know exactly when it began. It didn't just begin as a fuzzy parliamentary notion. The framers of the Constitution, being very much aware of this, really of the value of this type of protection and property right, were very clear. They put it in Article 1, Section 8 of the Constitution, in a very innocuous sentence that basically set up the entire media business or businesses that we know today. And the sentence is wonderful. It basically creates an automatic conflict, which has been in balance for the last 200 years. On the one hand, it secures for a period of time what's almost a monopoly for authors and creators of certain types of works. And on the other hand, it balances as a public policy the rights of the people of the United States to have access and use these creative works. And so it's encouraging the financial end of it, the monetization of creativity. At the same time, it's not doing it excluding the American people. We have a right to basically have access to these works and to use them accordingly and to reuse them as long as we comply with the statute. The evolution of the statute is a really fascinating thing. As I mentioned a moment ago, the people who framed the Constitution were way ahead of the times, and that was a unique type of law recognizing certain protections for intellectual property. Almost immediately, they became or got behind the curve. What happened in the 19th century, the following 100 years after the Constitution, we see an explosion of technology. And from that point forward, the copyright laws have always been behind what's happening in technology. And this is not an abstraction. I mean, this is real. Originally the copyright laws were very narrow in the types of works that they would protect. And every 10 or 20 years, the Congress of the United States would amend it and include greater and greater types of works and increasingly abstract types of works. And what was happening is there was a greater and greater need to expand the purview of these laws because of technology. The classic example would be the advent of the player piano toward the end of the 19th century. And this was used as a marketing tool for publishers. And the publishing industry at the end of the 1800s was a very, very, very robust industry, selling tens of millions of copies of sheet music. And so basically, player pianos, which were profoundly cutting edge at that time, were a vehicle for marketing and advertising new music. And it quickly became evident that this type of use of the music would be subject to, or could be subject to, the copyright protections, and that the people who created and owned these rights should be in some way compensated for this use. So you have in the early 1900s a pretty large amendment of the Copyright Act, and it was also at this point that they started recognizing the advent of radio, which initially was not going to really be much of an outlet for music, but in the teens, the 19-teens, it became increasingly an outlet. And about this point, you start seeing the development of ASCAP and later BMI and the performing rights organizations that were all set up to help protect the accrual of monies from these types of exploitations of copyrighted works. And we've seen this, and it's a very fascinating thing. It goes through the 20th century with films, and then talking films, and with radio broadcast, later TV broadcasts, and you can just follow really the changes in the law as the technology has appeared. But always the changes have lagged, this technology, and it's becoming an exponential lag now as we're in the 21st century, because even the most recent wholesale revision of the Copyright Act, which was the 1976 Act, did not foresee the extent to which computers and the internet in particular would impact the businesses. And so that has really, from that point forward, it's been almost impossible for the Congress to do anything more than create laws that serve as a Band-Aid to really gaping wounds and really loopholes that have allowed for a lot of different uses of property and some possibly illegal uses.